Again, good morning. My name is Rachel, and we are Law Office 14. As 1L students at Northeastern University School of Law here in Boston, we have the opportunity to participate in the Legal Skills in Social Contexts, or LSSC course, which is a unique first-year social justice program that prepares students to use law as a tool for social change. All 1Ls are divided into law offices in which they are assigned their own specific project. Our law office is under the supervision of Professor Sarah Lee Day with the assistance of our upper-level law fellows, Preston Osman and Hannah Cutler. I will now introduce the LSSC project we have been working on for the duration of our 1L year. So the title of our project is Full Disclosure, Empowering Workers to Speak Out Under Non-Disclosure Agreements. On there. So again, we've been working throughout the duration of our 1L year on this project with our partner organization, the National Whistleblower Center. I'm going to now walk us through what our presentation will look like today. So first off, I'm going to introduce who the National Whistleblower Center is, as well as our project, the background research we conducted, an insight into the decisions we made regarding our final project, and ultimately what that final project looks like. We'll be saving questions both on Zoom and in person for the end. Just as a warning to all, we will briefly be discussing sensitive content, including sexual assault, within this presentation, so please feel free to leave at any time. Okay, who is the National Whistleblower Center, or NWC? They are the leading nonprofit dedicated to protecting and rewarding whistleblowers around the world. They assist whistleblowers in finding legal aid, advocate for stronger whistleblower protection laws, and educate the public about whistleblowers' critical role in protecting democracy and the rule of law. The NWC has been instrumental in the enactment of key whistleblower protection and reward laws, such as the Dobbs-Frank Act, the Sarbanes-Oxley Act, and the Whistleblower Protection Act. The National Whistleblower Center's mission is to support whistleblowers in their effort to expose and help prosecute corruption and other wrongdoing. The NWC helps whistleblowers exercise their rights through education and training workshops, reports, and regular postings to their social media and website channels. Our LO was tasked with creating a social media campaign for the NWC, specifically relating to the role of non-disclosure agreements, or NDAs. Our project required research into NDA precedent and federal and state employment laws, interviews with whistleblowers and whistleblower attorneys, legal writing, and the implementation of creative work, including the use of Canva, a social media presentation tool. The aim of this project was to assess what resources a potential whistleblower might need prior to whistleblowing, specifically when they have signed an NDA. Our goal was to arm people with knowledge before they blow the whistle, but also to help inform them of their rights if they are unfamiliar with the concept of whistleblowing or the influence their NDA may have on their ability to speak out in their work environment. The final project is a Know Your Rights Instagram campaign centered around state-level restrictions on NDA. This campaign has been developed to be appropriate for use by the National Whistleblower Center in their use of social media to communicate and educate the public. I will now be passing the mic to Tim to give a quick background on whistleblowing.
The whistleblowing has been an established means of combating fraud and illegal activity for centuries, with the conception of whistleblowing being traceable to medieval England. In the United States, the modern concept of whistleblowing was established with the passage of the False Claims Act in 1863, otherwise known as the FCA, which was passed to combat widespread fraud during the Civil War that was resulted from deceptive defense contractors who furnished defective items to the Union Army, such as rotten food and faulty weapons. The FCA allowed private citizens with information of wrongdoing to bring a lawsuit on behalf of the United States government in return for a share of the penalty recovered in a successful suit. This kind of provision is commonly known as a qui tam provision, which is a shortened version of the Latin phrase that translates to "he who prosecutes for himself as well as for the king." Today, in addition to the FCA, the primary federal whistleblowing related laws are the Sarbanes-Oxley Act of 2002 and the Dodd-Frank Act of 2010. Compared to the FCA, both these acts are narrower in scope and are generally limited to the financial world and the reporting of financial misconduct. Sarbanes-Oxley was designed to reinforce corporate accountability and transparency by preventing retaliation against employees of publicly traded companies who disclose violations of SEC violations. The Dodd-Frank expanded upon the Sarbanes-Oxley Act to define whistleblowers as any individual who provides information relating to a violation of the securities laws of the SEC. As for the individual, being the person who actually blows the whistle, Studies have shown that personal factors such as tenure at a company, increased pay, and higher levels of education all increase the likelihood of an individual blowing the whistle. Additionally, older employees are more likely to be whistleblowers than their younger counterparts, specifically those 35 and younger. This data suggests that individuals who are more comfortable in their positions within a company have a higher correlation with blowing the whistle. So both whistleblowing and NDAs have been thrust into the limelight over the past couple of decades, with one event in particular that prompted their nationwide discussion being the Me Too movement. As many of you are familiar, the Me Too movement gained national attention following accusations against Hollywood mogul Harvey Weinstein. The movement indicated a seismic cultural shift in America by bringing to light issues related to sexual harassment and unequal treatment in the workplace. While Me Too garnered national attention and took major steps in highlighting deep-rooted issues in the workplace, those problems identified by the movement unfortunately continue to plague the country and cause people serious and lifelong harm. One of the most powerful tools used to perpetuate issues relating to sexual harassment and other intolerable behavior in the workplace are non-disclosure agreements, NDAs. However, at the federal level, there are protections for whistleblowers who breach an NDA. For example, the Defend Trade Secrets Act has a public policy provision that offers immunity to those who disclose confidential trade secrets to government officials in order to report a violation of the law. Courts will not enforce an NDA that prohibits an employee from blowing the whistle on the employer's illegal activity. Another statute is the Federal Obstruction of Justice statute, under which an employer is prohibited from retaliating against any person or their livelihood who provides law enforcement with truthful information relating to the commission or possible commission of any federal offense. Finally, the Federal Speak Out Act, which is most closely related to the issues highlighted in the Me Too movement, prohibits the use and enforcement of NDAs between employers and current, former, and prospective employees in cases of sexual assault and harassment. While the Act leaves room for states to enact their own laws, specific laws on NDAs, the language of the Act narrowly reframes the conversation around NDAs and whistleblower protections to focus on cases involving sexual assault and harassment. That said, despite significant strides and the legislative actions it has highlighted, misconceptions persist that inflict enduring harm on individuals across the country. And with that, I'm going to pass the mic to Annabelle, who will talk a bit about our goal we had in mind for the project and our target audience.
Thank you, Tim. So I wanted to start us off with a story of a whistleblower and someone who did break their NDA. So I'm going to start us off with Ifeoma Ozoma's story. When we think about corporate whistleblowing, we might think of a C-suite executive or another similarly high-level worker. That person is probably older, they're whiter, and they're part of this old boys society that governs so much of our society today. The whistleblowing might be about money, it's likely about trade secrets or maybe fraud. However, in the wake of Me Too and the Black Lives Matter movement, new forms of whistleblowing are taking the spotlight. So let's take a look at this case of Ifeoma Ozoma. Ozoma was part of Pinterest's public policy team. In March 2020, she quit her job after facing frustrating months, asking for a pay raise in concert with her accomplishments and credentials, being attacked and doxxed for her work, and got berated and humiliated by managers throughout her time there. Long after she quit, she wasn't allowed to say why, having signed an extremely restrictive NDA about her work and what she experienced. Finally, after seeing Pinterest's surface-level support for Black Lives Matter online, despite not protecting their Black employees for real, she came forward. She detailed her experiences blowing the whistle on Pinterest's racist and discriminatory behavior against her and other people of color, despite the possibility of being sued into bankruptcy. Though she gained national attention and was able to bring that energy and awareness to her cause, she noted later that it was in fact the failures of the Me Too movement which kept her from speaking out. The people who rose up during that movement and were highlighted didn't look like her, and their cause didn't uplift her and others who were facing other kinds of discrimination and harassment. It was the lack of intersectionality inherent in the movement that inspired her to push for legislation which protects everyone, the Silence No More Act. The Silence No More Act outlaws discrimination or harassment on the basis of any trait, for example, race, religion, age, or sexual identity. It has been passed in California and Washington, and some of the biggest tech companies have committed to its provisions. Ifeoma Ozoma's case was different. It's a mark of how the corporate landscape is constantly changing. And with those changes comes the need for increased protections and resources for those workers that don't have the experience connections, or financial stability to properly navigate the under-regulated and treacherous realm of NDAs. We want to reach under-resourced, marginalized people like Ufoma Ozoma. So our goal, therefore, was then to reach these younger, entry-level, marginalized workers. And we started from this idea about misconceptions, as Tim had mentioned earlier. We believe that misconceptions about whistleblowing can stifle someone's ability to speak out, and we have identified two common skewed views of whistleblowing. Either one, a burden on someone's workplace, or two, a betrayal against that person's employer. And we believe that younger workers are, in fact, particularly susceptible to these ideas. So we wanted to recast whistleblowing in a positive light. We have this goal of reaching the young worker, the marginalized worker, and arming them with knowledge and resources. So really, what does that entail? Well, first, who is the whistleblower? While the decision to blow the whistle is a deeply individualized issue, as Tim had mentioned earlier, what it often comes down to is that blowing the whistle is a trade-off between honesty and loyalty. Predictors of whether a worker will become a whistleblower are determined by how much organizational support and encouragement an individual feels that they receive, as well as the existence of safety measures to protect these whistleblowers from retaliation. Borne out by the research, when a whistleblower feels empowered and safe, they are more likely to blow the whistle. Someone who is thinking about blowing the whistle, though, likely does feel upset, betrayed, or unsafe. We are hoping to show them that they do have the power to make a better workplace. By highlighting the individual and collective benefits of whistleblowing, we believe that our audience will be persuaded to act. So in this project, we're hoping to clarify the risks and protections around any instance of whistleblowing that involves NDAs, especially in these cases that are less traditional and don't really reflect this precedent set up by the False Claims Act, Dodd-Frank Act, and Sarbanes-Oxley Act. There is a baseline set of whistleblower protections around NDAs at the federal level, but often the question of what affects a whistleblower and the tools most important to them are at the state level, as we see with the difference between, for example, the Speak Out Act and the Silence No More Act. So one federal, one state. And while different states do have varying policies and regulations surrounding NDAs, many of them are at this moment continuing to expand. In fact, I think one of the states we had looked up, they had just passed some regulations like a month ago. So it's definitely a very evolving space right now. And so they're continuing to expand to provide protections for employees against unjust restrictions on their ability to speak out. And finally, why? Why entry-level workers? Well, for one, entry-level workers are a particularly vulnerable population because of their youth, because they likely have little experience with navigating their legal rights. We also believe that reaching workers at the beginning of their career can cause a sea change in the workplace as a whole. And we believe that starting there can fundamentally change the workplace. Workers can break perpetual cycles of harm when they feel empowered to call attention to the wrongful behavior they have endured or witnessed. And it is only then that we can have an equitable workplace. So next, I'm going to pass the mic to Rachel to talk about some of our methodology and some of what we learned.
All right, so when we were doing our research to prepare for this project, we conducted multiple interviews, two with lawyers, one with an anonymous person who signed an NDA, and one with a social media manager to get a sense of how does social media function, how do posts get popularized. So our first interview was with Stephen Cohn, a renowned whistleblower attorney who has a deep knowledge of the extensive history of whistleblower law because of all the work he has done for the movement and procedures. From this interview, our main takeaway was that whistleblowing is a long process that requires a lot of patience, and that's something to be prepared for. Also, that whistleblowers are everywhere and they exist on all levels of power. The next person we interviewed was the person who signed an NDA as an entry-level worker. From there, we saw in real life what our research reflected. People have misconceptions about whistleblowing and do not understand what protections are in place if they want to speak out. Finally, we talked to two lawyers, two attorneys at the firm founded by Stephen Cohn. During this interview, we learned that there's typically a catalyst for whistleblowers. That means there's something that triggered the decision to speak out. The straw that broke the camel's back, if you will. And finally, Mr. Keltree emphasized that potential whistleblowers really do need to be careful who they talk to if they want to get the protections that they can get. And that's something we did our best to reflect in the carousel. The other person we talked to, the social media manager, I'll talk a little bit about later. Social media in particular is something we liked for this project because it's become a platform for civil engagement and activism. And we wanted our project to serve as one of those calls for activism, as well as an introductory resource that we hoped would reach people because of how widespread social media is in news consumption these days, with about half of US adults learning their news from social media. We like Instagram because the age of its user base skews towards younger individuals, which aligns with our target audience of entry-level workers. In our conversations with the social media manager, we were advised of the importance of engagement and visibility with the Instagram algorithm. And Instagram's post visibility depends on the engagement it receives immediately after posting, which makes this algorithm more likely to pick up that post and show it to other people. Because of this, the first few minutes after posting are crucial for obtaining likes, comments, and shares. Because of this, we recommended that the carousel be posted at times when the NWC's previous Instagram posts have received the highest level of engagement. You can find this information, or they can find this information, by looking at their business Instagram page, which gives access to its profile's analytics, including trends, access to who following, content performance, and user engagement. Also, in order to boost this post engagement, we made other recommendations, such as reaching out to like-minded organizations and asking them to share our carousel once posted. These are known and trusted organizations with audiences that already have an online relationship with the NWC. Also, because larger events or days of awareness bring attention to issues and make people more likely to pay attention to them, we suggested posting the carousel on National Whistleblower Day, which is July 30th of 2024, to increase engagement as well. Now I'm going to pass this to Katie to talk about design.
Thank you, Rachel, and good morning, everyone. I'd like to first begin by talking about our design philosophy. To inform our Know Your Rights campaign, we analyzed similar social media campaigns used by companies, government agencies, nonprofits, and activist groups. We identified the common design elements to these campaigns that we liked best. This includes things such as the organization of a slide, how groups chose to visually present information, and what made a slide more or less legible, and so on. We then implemented those common design elements into our own carousel. The information on each slide is presented in a straightforward and accessible manner. Instagram is a very flexible platform, but there are also size constraints at work. So every slide was designed to avoid overcrowding and bloated text. The deliverables design also uses easy to read fonts and maintains a consistent aesthetic. Specifically, we chose blue color tones as the background to match the NWC's existing theme. Given Instagram's capability to share individual slides, each frame has been developed to potentially stand on its own. Another important consideration for us when designing our slides was accessibility. Taking accessibility into account included making design choices such as using high contrast colors and text that is easy to read. Conforming with industry best practices, we checked the colors to make sure that they were easily legible for people with low vision. We used a website and resources created by the group Web Accessibility in Mind. Our slides are also a mix of infographics and textual information. We tried to make each post easy to read and organize the slides to flow as logically as possible. We have also written alt text that will be present in each Instagram slide. Alt text is used to describe images and graphics. These descriptions are helpful for people with visual impairments or who may be using a screen reader. Future avenues for accessibility could include translations into other languages. For the last part of our methodology, I'd like to talk about our research on state laws regarding NDAs. As Tim mentioned earlier, the Federal Speak Out Act prevents the enforcement of NDAs in cases involving sexual assault and harassment. While this is certainly important legislation passed in the wake of the Me Too movement, it also inadvertently narrowly reframes the conversation to focus only on sexual assault and harassment. And so over the last few years, some states have enacted their own laws limiting NDA usage. These laws may mirror the Speak Out Act or supplement and even expand on the act to limit NDAs under circumstances beyond sexual assault and harassment. We dedicated a slide of our Instagram campaign to highlighting these state-specific laws because we believe this information was both incredibly relevant and helpful. Knowing which states impose additional limitations on NDAs will help potential whistleblowers make a more informed decision. For our methodology, we researched and analyzed the language of each state's NDA-related statutes and noted the restrictions and protections afforded. When researching state laws, we found it difficult to locate a single comprehensive resource with up-to-date information on these state-specific NDA laws. Furthermore, we had to read and analyze the statute ourselves and then translate them into plain language for our own understanding. For these reasons, we decided to create a map, our own map, that contains all this information organized using an easily understandable color scheme. There are a wide variety of restrictions, so when we designed our map, we categorized the states based on the scope of their protections to keep the map reader-friendly. Each state is color graded based on the scope of their NDA laws. States that do not impose additional limitations on NDAs are colored in white. In these states, NDAs are restricted only by the Federal Speak Out Act. States that impose additional restrictions and limitations on the usage of NDAs in cases involving sexual assault or sexual harassment are colored in light orange. States that limit NDAs under broader circumstances, including sexual assault and harassment, retaliation, and general workplace misconduct, are colored in darker orange. The grading system is also set out in the map's legend on the slide, ensuring our audience can readily understand the color distinctions. And with that, I'll hand off to Cameron and Katie to discuss our Instagram slides.
Thank you. All right, I'm Cameron.
I'm Katie.
And now we're going to get into the good stuff. We're going to talk about the Instagram carousel itself. It's all been good. I didn't mean like that. All right. So above me is an overview of all of our slides. We ended up with a carousel of 8 slides and then an additional resource page designed for the NWC. So this is the first slide of our Instagram carousel. It's what viewers are first going to see. It's really important. So we tried to design it in a way that would entice people to keep looking through the post, to keep swiping. Keeping that in mind, we kept things pretty minimal, direct, and we wanted to get our message across. This is about workers. This is about empowering workers to speak out, and we tried to make that clear. We used 2 different pictures in this first slide that portray typical workplace environments that usually have whistleblowers or have had whistleblowers in the past. One is a more white-collar job. You see someone in a lab working on something sciencey, and someone else on a construction site, a more blue-collar type of job, just to also demonstrate that whistleblowing happens across all types of employment. A certain whistleblower does not look any particular way. If you'll also notice on this slide, we don't actually use the word whistleblower. We realize, as you've heard throughout this presentation, that there are a lot of misconceptions about whistleblowing and that it's bad. So we want people to get used to the idea that they can speak out even though they've signed an NDA without all of those negative emotions attached. They're not going to be thinking, oh, I can't be a whistleblower. I don't want to be that. People don't like whistleblowers. They're just thinking, oh, I can speak out. That's good, even though I've signed an NDA. So we want people to make this connection, and then we can bring in whistleblowing later in our carousel. So on this slide, this is a simplified definition of an NDA, just getting everybody on the same page. We wanted this information to be easily digestible for entry-level workers who may not really understand what an NDA is or how they impact whistleblowing. So to make sure that everyone understands, we just digested that information, put it into more layperson's terms. And in addition, it's commonplace for some employers to use different names when it comes to NDAs to kind of try to trick the workers. So we wanted to make sure that people understand that these different names might be in place so that even though they've signed a confidentiality agreement, they get that it's the same thing. We're all talking about NDAs. So we're just using this slide to get everybody acquainted with the information and so that they can keep scrolling, realizing that it applies to them. This is our speak out slide. So this slide does what the last slide did for NDAs for whistleblowing, keeping that simple definition, layperson's terms, realizing that it's complicated legal jargon, but we're trying to make it as clear as we can, that it's just telling someone something, you're reporting misconduct. It can be very simple. And we just are really encouraging people here to speak out if they have something to say, if they need to alert someone of misconduct. We also this is where we're really working on breaking down those misconceptions you keep hearing about. Whistleblowing is not tattletaling, you're not a snitch. We want people to know that whistleblowing can be a really good thing. And so in order to get people used to it being an empowering tool, we really need to break down these misconceptions. So this is what we do with that slide. And we focus on that, hear what whistleblowing is not so that they can obtain what whistleblowing is and understand it. So we're just targeting, again, those common barriers of whistleblowing and just trying to break them down so that people will take action and report misconduct that they see.
Thank you, Cameron. So this slide discusses what comes next after you've signed an NDA. Even though NDAs restrict what an employee is allowed to disclose, there are still some things that can be reported regardless of the NDA. Those things include wage theft, sexual harassment, and racial discrimination, and any other illegal activity. As aforementioned, there are federal and state protections that further address these issues. On the other hand, there are still elements that are not reportable once the NDA has been signed. These generally include trade secrets. However, it's important to consult with an attorney before disclosing any information because a trade secret might be able to be disclosed in relation to relevant wrongdoing. We included this information in our carousel to serve as a quick guide for identifying red flags that might pop up in an NDA. We also included a legal disclaimer down at the bottom of the slide to account for the statutory inconsistencies across the country. This slide discusses the benefits of whistleblowing, which generally include accountability, compensation, and positive change in the workplace. We included these benefits in our carousel to reframe whistleblowing as a moral imperative and incentivize a potential whistleblower to speak out. First, whistleblowing holds companies accountable. Without employees reporting wrongdoing, companies would be able to get away with illegal activity, which might ultimately harm the public. Whistleblowing mitigates the harm, preventing it from occurring or from getting worse. Second, whistleblowers may receive compensation for any misconduct they report. For example, high-quality original information that leads to an enforcement action over $1 million in sanctions may lead to an award between 10 and 30% of the money collected for the whistleblower. Third, whistleblowing makes a positive change within the work environment, as it fosters a more transparent workplace and prevents any misconduct from occurring or continuing to happen. Notably, there are time limitations concerning when a whistleblower can file certain legal claims. These are often referred to as the statute of limitations. If a claim is not filed within the noted time frame, the claim will no longer be accepted and no further action is allowed. Due to the range of deadlines across jurisdictions, it is critical that a whistleblower acts early. NDAs must also be precise in the scope of what information they cover. For example, an NDA cannot restrict an employee from disclosing general knowledge they acquired during their job or information that is public knowledge. NDAs must also be specific in how long they last once an employee has left the company. Lastly, different states and laws have different protections. These protections determine whether certain information can be exposed. There are uniform federal laws that all states must follow, but there are gaps in federal legislation that the states can fill, leading to varying protections in different jurisdictions. It is imperative that potential whistleblowers are aware of these differences, as their rights are not the same across the board. This slide specifically addresses NDA-related laws at the state level. As my colleague Katie mentioned earlier, we created this map to inform our audience that the federal law isn't the only place they can turn to for protection. We thought the color-coded map would be the best way to convey state-specific laws to our audience, as they can easily find their state on the map and identify what level of NDA protections their state affords. The states colored in white are subject to just the Federal Speak Out Act, while the states colored in light orange have additional restrictions on cases involving sexual assault and harassment, and states colored in dark orange have broader restrictions on NDA usage. We also included a legal disclaimer at the bottom to encourage our audience to consult with an attorney to gain a better understanding of their state's NDA laws. This slide addresses the sources that potential whistleblowers should be cautious about in speaking to first, including the media, companies' human resources departments, and other internal reporting channels. We wanted to deter potential whistleblowers from going to the media first. With the rise of the Me Too movement, and the media's coverage of it, the media might seem like an attractive option for a potential whistleblower to be heard. But going to the media could violate a potential whistleblower's NDA and jeopardize the legal protections afforded to them. Over the course of their journey as a whistleblower, going to the media might become an option, but we want to deter them from using it as their first option. Likewise, we want to deter potential whistleblowers from going to personnel within their company first. A company's human resources department functions to benefit the company, not the employee. And so we want to deter them from going to the employer. Once a company discovers that an employee might expose misconduct, they identify that employee as a potential troublemaker and start to assemble a file against them. We want to discourage the potential whistleblower from going to their company to mitigate the risk of being retaliated against. Now I will turn it back to Cameron to finish up the slides.
All right, so this is our final slide. We hope that at this point, the user has seen all this information and now that they can use this as a jumping off point to really take action and take that next step. And the best place to do that is at the National Whistleblower Center's website. So we guide the viewer to 3 different places on the website that are particularly helpful. First, we guide the reader to their legal protections page. This website really provides great resources about what the law is generally, and we hope that this social media campaign can connect people to it. There's probably a disconnect between people that are on Instagram and getting their information that way and people that are doing searches on the internet. So we want to really bridge that gap, get people access to this information, and particularly young people who are on Instagram. We really liked the idea of being able to just cite all of this stuff to one URL and have all of this information there. If we had tried to cite to a bunch of different places, different statutes or pages, that's really complicated, and we wouldn't expect someone to go through all that trouble to try to get the information that they need. So this really focused on streamlining the process, making it as simple as possible, because that's the best way that people are going to use it, is if it's easy. Second, we recommend people looking at stories of people who have blown the whistle. So we didn't include any of these stories in our actual Instagram campaign because, number one, space, but also we don't want anyone to feel like a whistleblower has to look a certain way or have experienced a certain journey to speak out and blow the whistle. Because whistleblowers look different, they have different experiences, but we hope that maybe someone who's thinking about blowing the whistle can read these stories and feel inspired by them. These stories show potential whistleblowers that there are real, pretty scary consequences of blowing the whistle, but there can also be huge benefits that make it all worth it. We see stories about compensation, becoming advocates, creating better workplaces, and helping safer working conditions as well. And then finally, we direct the viewer to the NWC's secure intake form, because so many of the routes that whistleblowers can take could potentially end up harming them and their legal protections. The best way to ensure that this is enact is to speak with an attorney. This is essentially the most tangible step that we can offer. Fill out this form and you can get connected with an attorney today. We really stress throughout our entire Instagram carousel that it's very important to talk to an attorney. We have warnings about consulting an attorney, ask an attorney, and it's nice to be able to say, not only do you really need to talk to an attorney, but here's where you go to do that. We're able to connect people to that resource. So we're really glad that the NWC offers this resource, and hopefully this Instagram campaign can connect people to it. And then finally, this is our resource landing page. This is just kind of an extra resource outside of the carousel that the NWC could use, maybe post it on their story or use it as a landing page from their link tree. Just because there's so many different resources out there, this gives the user a direct route to get to each link just with one click. Just again, making things as easy as possible so that people are more likely to take action. And again, and also we know that people who are thinking about blowing the whistle are commonly fighting feelings of loneliness, that it can feel like a very isolating process, and seeing all these resources in one place can hopefully help someone feel that there's groups like the NWC out there that really want to help you and be on your team as you go through this, to really make people feel more together and have a group behind them as they go through the scary process. And this is what it will look like, thanks to some Photoshop magic on the Instagram page. And with that, I'm going to pass it over to Etta to conclude us.
Thanks, Cameron. So just to sum things up, we talked about how NDAs are being used more frequently in various situations. and how they're being weaponized against whistleblowers and to unlawfully silence employees from every walk of life. While there are risks, blowing the whistle ultimately changes both one's workplace and, on a larger scale, society for the better. NDAs and whistleblowing may seem daunting, especially because these words are surrounded by and are themselves legal jargon. But by creating this Know Your Rights campaign with the NWC, our law office hopes that we were able to provide concrete information in an easily digestible and accessible format. Our goal was to not only inform people of their general rights under whistleblowing, but to show them that NDAs are not an end-all be-all. We wanted to rewrite the narrative surrounding whistleblowing and portray it as a moral duty to encourage people to blow the whistle. Through this resource, we hope to be the catalyst that encourages entry-level employees to advocate for themselves and for others by blowing the whistle. Thank you. And if anyone has any questions, we'll take them now.
Questions?
Mike?
I noticed that you guys did this on Instagram and you talked a little bit about the Instagram algorithm, but there are a ton of social media websites out there. You have X, TikTok, Facebook, and probably many more that I don't even know of. What specifically drew you to Instagram? Do you elaborate a little bit more on that?
Yeah, I can take that one. Great. So yeah, when we were deciding between a social media platform, it definitely crossed our mind that there are various platforms, specifically TikTok. We threw out the idea of creating a reel at one point, but didn't think that was really realistic. We saw Instagram and we looked at a bunch of different campaigns as part of our research and explored other platforms and what they've done in the past. With TikTok specifically, the credibility aspect didn't really come through. It did reach our audience that we were trying to target, but not as much the credibility, again, that we were trying to portray. Instagram, while still a social media platform, does have that aspect that allows you to share more easily. We see it too, also crossing multiple generations and having parents, kids, all people are using Instagram. YouTube, I'd say, is not as shareable and again requires more of a video. And we were looking for more information that is readable, digestible, and presentable. And so for those reasons, that's why we sort of stuck with Instagram. But it's definitely something that I think the NWC moving forward can translate this project to other platforms as well. So they do have a Twitter or X, and this type of platform can be reshared on X. And so it's just the formatting of it was more accessible.
Any other questions? Jordan?
It seemed like you guys had a lot of information that you had to condense into slides. So what was kind of the biggest challenge you had trying to keep everything informative but still succinct?
I think one of the biggest things was actually choosing what to include and what not to include, and what we thought would be the most important for someone to know, what would be the easiest for people to understand, and at the same time not scare people away from whistleblowing, because it is scary. There are risks, and we want this to be something that encourages people, something that's informative, but still not overwhelming. Anyone has anything like that? That's good.
We actually have a question from Zoom.
Yes.
What were some challenges you faced while researching state level whistleblowing protections?
This will also almost answer Jordan's question, the last question as well. There's just so much information. When Katie and we were handling the state by state level research. It's a very, I guess you would almost say macro level kind of topic. And it requires so much information and detail that it could be an Instagram campaign on its own. And so when we were making our map, Katie and I had to make a lot of final tough choices on how to frame the map and the conversation around it entirely. Ultimately, though, we chose to do something that we thought would be easiest for people to digest, especially in the midst of the rest of the campaign. The map, after all, is not the last slide. It's smack dab in the middle. And so we don't want to overwhelm people so much that they don't want to finish the rest of the post. Katie, is there anything you would add?
I think another big challenge that we face with the map is just parsing the legal language. We were doing it throughout the course of most of the year. And so there were times where we definitely had more of a legal background than we did otherwise. And so I think looking at this language, having somewhat of a legal background and saying, how do I take this information and give it to someone who has no legal background was very difficult. But I think that was probably the biggest goal of the map, was to be able to distill all of that legal jargon and background down into something very digestible for a non-legal audience.
Camille.
Great job, y'all.
Thank you.
How do you see the scope of what NDAs cover kind of change moving forward or not change moving forward?
Changing going forward. I think that there's kind of a movement to be had about workers' empowerment that's coming up. I think so much of the history of NDAs had to do with the Me Too movement, where people are aware of NDAs strictly in this like harassment context. But hopefully there needs to be like a more expansive understanding of like, we can break NDAs because illegal stuff is going on. And if your workplace is bad, like you have a right to change it and you have a right to get help and fix it. And so I think it needs to head, I mean, that's just my personal, like, I think it needs to head that direction, that like maintaining this momentum of like harassment still being horrible, but also realizing that there's so many other areas that this needs to cover, just kind of expanding that and hopefully just like empowering workers overall. And Annabelle?
I think it's also just a generally, we see the labor and employment like landscape changing a lot right now, though just ideas about like what you can do in the workplace and like who has the power in the workplace are really shifting right now, as we see also here in Northeastern. And I really think it comes down to the fact that like there's no such thing as like an illegal strike unless the strike does not work. If you break your NDA and it's in support of something illegal that is happening, then it is. I cannot say that it is not illegal necessarily, but it really, if you're successful in your movement to fight against illegal, unfair practices, then you're successful. And I think that's what we'll see more of going forward.
The final comment I'll add is that we're really starting to see NDAs enter into the mainstream conversation. Since in the wake of the Me Too movement, it's been gaining greater traction in the news. There are things about Boeing in the news right now, for example. And furthermore, I think that this is all just the conversations that are happening around it are picking up the pace. For example, when we were making our map, Katie and I realized that Utah passed NDA laws the last week of February. And so we had to last minute update our map because it's just that up to date, like rapid changes. And so I think that just as everyone has been saying, there's this real movement and conversation around this moment. And there's a reason for it, definitely.
We actually have another question from the Zoom. OSHA and Title VII have certifiable and other agency-related means to be protected from retaliation rather than solely the letter of the law, which in many cases have no teeth to protect on a practical level. Are there efforts being made to extend such validations or protections against retaliations to whistleblowers as a whole? I don't mind answering that, honestly. I'm Owen, by the way. Honestly, I think that really just connects back to what Katie was just saying in terms of things are moving and progressing so rapidly, even in terms of the map, having to go back the very last second and change the map is because it's such an evolving landscape. So to really answer that question, yeah, efforts are being made daily. And that's really the purpose of the project, is to continue these efforts and to help this change continue along, because as Katie was saying, echoing that sentiment, that we really are in a moment right now, which is why I think that this project specifically at this moment is very intentional and very purposeful for what it's seeking to achieve.
I think also in the wake of, well, in the continuance of COVID has been like an interesting movement for worker rights in general, just because so many jobs went online and have had this influence of not as intense working conditions, I think, for a lot of people. And so they're kind of coming to this understanding that they are entitled to have a good workplace. And so if they're not getting a good job somewhere, like they can go work somewhere remote and have like a great stay-at-home job and just get more privileges. So I think people are having to like put more things in place because people are realizing that they have power as like an employee, especially post-COVID. So like Owen said, we're seeing more of a resurgence of workers' rights stuff.
Eli?
Well, I first want to commend you guys on a great presentation that I think illustrated the importance of being able to marry legal analysis with extra legal skills that are important to getting the word out. Kind of at the risk of being redundant with the last two questions, as someone who's never interacted with an NDA, like what kind of things other than trade secrets typically are in NDAs? And I guess to your map and like the dark orange states that provide protections for more than sexual assault, what kinds of things are you guys seeing that those states are protecting? And is that perhaps maybe pointing the way to what the future of NDA regulations might look like?
This is going to be a very granular answer, so I apologize. I'll try to make it, I've just been so in the weeds of this state research, man. It's like I'm speaking a different language at this point. One thing we did not address in the map, simply because again, it's so granular, is a lot of these laws distinguish NDAs pre-dispute versus post-dispute. So a pre-dispute NDA is signed usually as a condition of employment at the very beginning of your hiring or as a condition of continued employment. And so it's pre-dispute because nothing has happened yet. And so the Federal Speak Out Act is purely addressing pre-dispute NDAs. Many of the states also are only pre-dispute NDAs. And that reflects a kind of the kind of current, let's say, cultural moment about how we want to limit NDAs, and that we don't want to limit people from the moment they start their job. We don't want to restrict them in their ability to speak to law enforcement, to lodge a civil complaint, and so on. Some of the states, particularly the orange-colored, dark orange-colored states, also have laws that address NDAs post-dispute. So NDAs that were signed as, let's say, a settlement or a severance or a separation agreement. So the misconduct has already happened and the employee has already gone through the process. There is a real reluctance to entirely limit or restrict NDAs in the post-dispute context because, again, we want survivors to be able to go through the process and get some kind of settlement award and so on. And there's concerns that if there's no kind of regulations or if we take the cap off too much, then that would disrupt that process. But some states are beginning to do these regulations of the post-dispute NDAs, largely in the context of whether or not you can speak about it at all. If that makes sense, the settlement, disclosing the settlement award amount and so on. I have definitely lost the question in that explanation. So please let me know if I did not address something.
You also mentioned like what else do NDAs address other than trade secrets? I saw when I was doing some research, like NDAs like discussing like new technologies and like protecting those before like they went out a bit. Like I read a court case where they could not get protection via contract law after another country used their technology, but they were able to get some protection, some sort of settlement because they had signed an NDA with the other company, which then disclosed. So you might see something like that, which is the use of an NDA that like I don't think this group has a problem with, like two companies being like, hey, don't talk about who uses this technology. That's very different than the harassment or the other things we've been discussing right now.
Yes. Okay.
Yeah.
Yeah. I was just wondering, and the answer to this may be no, because it's sort of a neighbor question to whistleblower, but did you run into any NDAs and how they interact with like your Section 7 rights under the NLRA? Because, for example, if there's an NDA that says you can't discuss your wages, that doesn't necessarily just affect like what I can't, but it affects my ability to talk to my coworkers to improve our collective conditions. Did you run into anything like that in your research?
I don't know if we ran into that explicitly, but NDAs can't stop you from like, NDAs do protect your rights. Just no, you can break NDAs to protect your rights to a certain extent. So I would wonder and look into if that would count as like an affirmative right. And if it's an affirmative right, like this is just, I guess, where I do the research. And if it's an affirmative right, then there could be a chance that could not be blocked, but it probably depend on the wording of the different statutes.
Yes, Professor?
First of all, congratulations. It's really a really interesting project, especially with the knowledge that, you know, movies and stuff around Harvey Weinstein and the trial and everything really produced a new dialogue around NDAs. I just want to also just say that, again, sort of the idea of being able to translate complicated legal issues across multiple jurisdictions into simple, accessible language is really, you know, a lot of what we've talked about in our class, which is unrelated in topic, but is related in terms of pedagogy and in terms of legal learning. So just really a shout out to your ability to do that. My question actually has to do with the larger question of being assigned a project at the very beginning when you got it, when you went like, what, or who, or this isn't why I came to law school, or this isn't my subject, or whatever. I just, again, I'm not gonna ask all of you, but if a couple of you feel comfortable saying how working on this project changed your idea of what you were interested in, or your opinion around what law can do, or anything else, like just sort of like what the experience of being assigned a project like this one has done to your idea of both your legal career as well as your view of social movements.
To start off, I think all of us had this experience, but I don't think we realized how many times we had to reevaluate what our goal was and how to achieve that goal. And just like, we had to start over a few times and we had to redirect our research elsewhere. So I think dealing with that as a team was definitely an experience. And I think, well, at first we were like, why would we make an Instagram post? Like, we're in law school. What's the connection? But I think learning that the law doesn't have to be as complicated as it seems to be, and that we can make it accessible to everyone was really cool to see.
I think in addition to seeing that some things are just super overcomplicated and they really don't need to be, for myself, it was really affirming to see how many times throughout our Instagram carousel it said, consult a lawyer, or you need to talk to a lawyer, which is a barrier and it can be very harmful. But as a person who wants to be a lawyer, it was like, oh, cool. I'm actually doing something that's going to give me the power to help people make their lives better. And so I think that was just exciting to see, like, oh, a lawyer, and that's going to be me. And I can hopefully will be able to do something like that one day.
I was just going to add right from the start, I think we were all very excited about the topic specifically because it was something that was going to be put out into the world and actually have true meaning and could really make a change in people's lives. With that came a lot of pressure, I think, in terms of wanting to make it right and give it the proper attention that it needed and not just put out something that was not credible or not worth people looking at. And so I think that was something that we all had in mind throughout the duration of this project, was just making sure, being mindful that this is something that wasn't just a school assignment, wasn't just for, you know, us to look at or our professor to grade. It was actually going to be something that had meaning and had purpose. And so for me, it was, at least that brought a lot of like pride and joy into like a project, and hopefully, you know, carries over into like a career. It's like Cameron was saying, we're making careers out of this, and it's just very fulfilling to see something be put into the world and have meaning.
I think for me, this topic in particular is applicable to the law in general, where there are so many misconceptions that exist in our society about the law. And so in terms of NDAs, like, coming in, I was of the belief that NDAs could generally contain anything they want. They could suppress anyone from speaking out. Very quickly learned that there are rights that people have, and they're not always the source of the stereotype in society.
Hi everyone, I'm Kat. I was doing the slides. But I just wanted to add that this project really bolstered my value of accessibility. I think that social media has really changed who has access to information. Typically before this, workers would have their rights violated and wouldn't know what to do and would have to really conduct their own research. I think that the law is an incredibly elitist institution. And so by doing a project that was centered on social media, we were really able to, I think, sidestep that elitism and talk to people who need to know these things. As lawyers, we are better able to understand what our rights are. And so to be able to do this work as law students currently, I think it's really empowering to know that in the future in our legal careers, we can really work on bolstering accessibility for our clients and for like the general public who need this information the most.
I think this project also just shows the immense power like an individual has. I hope this project shows that because we've been working on it for less than a year. We've been in law school for less than a year and we're almost subject matter experts at this point. So I hope that this project showed that if you spend time, you can learn these different facets of whistleblower law and you can distill it into language that is not legal jargon. And I hope we showed that.
Yeah, I can't attest to everyone's experience, but I know that coming to Northeastern, I didn't have a good sense for what the LSSC program would look like. And I remember on the first day of orientation, I met Professor Day and she explained that we would be doing whistleblower law. And I had this overwhelming sense of, I just got here, I don't even know where the classrooms are, and now I'm going to learn about whistleblower law. And so I think we were very fortunate to have TAs and a professor who have also gone through the Northeastern system, who are either NUSL students or a NUSL alum, who understood what LSSC demands, what it sort of feels like to be in that 1L position where you're trying to figure out who I am and also what will my career look like and also how do I help people on Instagram. And so I think we just had very good resources at our disposal that made the project much easier.
Lenny?
So first off, I like to say that like the graphics that you made, I thought were like really fantastic.
Thank you.
But speaking of that, like to separate your project into like separate skills, there's definitely like a design skill and like a research skill. And the research skill I know is something that we've been cultivating this year, but unless I missed some classes, you know, the design part isn't something that we were taught. And there's a lot of elements in that, right? Like there's stuff about like fonts, about color usage, how your eyes move through like a graphic. When you were utilizing that skill, is that something that some of your members already had? Did they have to like learn it? Did they have to research it in order to like utilize it here?
So for the most part, none of us are creatively talented. Professor Day is a little bit, but I think we spent a lot of time looking at other social media campaigns that were like know your rights oriented or just like informational, and that was really helpful. I think it helped us, like to Jordan's question, it helped us distill what we needed to include on each of the slides and what we didn't need to include, which I think was more important. And we talked to a social media manager, thanks to Preston, and she kind of helped us with the logistics of how we should go about designing and how we should go about posting. And then I think there was a lot of drafts that we went through. Like it was a lot of trial and error. We tried to match the theme to what the NWC's Instagram currently looks like, but also tried to make it stand out a little bit more from what their posts were. So I think it was like we just learned while we were doing it. I don't think it was anything crazy. I don't know if anyone wants to add.
I also think that design is not just like fonts and graphics. It's also it's a kind of thought and like this kind of iterative process that we just fell into quite naturally really, I think was the best way to come up with the final product that we did. By trying and failing and trying and failing over and over again, we really were able to figure out what worked and what didn't. And I think that will help us a lot in our future careers as social media managers.
similar to what Annabelle said, but also the trial and error was huge. And I think it was an interesting balance, as you mentioned, between the research and the design. The research did dictate a lot of the design. If the information was important, it was a matter of making sure that that information was front and center and making sure that the slide portrayed the information we wanted in a clear and legible way, but not letting it get hidden behind, graphics or design. Like, it was a huge part, but I think the research did tend to dictate what it was going to look like. And that changed, like, as throughout the course of our project, our first draft is significantly different because it is a growing field too. So like, as we were learning more and as we were growing in our research, that dictated what was going on these slides and what we felt was most important to portray. And we had to make some difficult decisions too, because, it's all important. And we'd love to make, a 20-page slide of everything, but that's just not realistic in terms of information and what people will be able to digest. And so it was a challenge, but I think it was also a really great learning experience.
We also looked at spent a lot of time scrolling on Instagram and seeing which campaigns caught our eye and just send them to each other and try to adapt that as best we could to make our slides catch someone else's eye.
We have an Instagram group.
Yeah, my favorite part was scrolling through Instagram for homework, so that was great.
We have another question from the chat. So why do you think so few states have legislation on whistleblowing specifically?
Katie, if you ever want to hop in on this. I think that I'll flip the question and say, what does it mean that states continue to pass legislation even in the wake of the Federal Speak Out Act, which was signed into law at the end of 2022? But even then, I'll back this up. So there are currently, I believe, 17 states with additional NDA limitation laws on the books. 10 years ago, none of these states had these specific limitations. And so what it goes to show is, going back to what I said earlier, it's this cultural moment that we're enmeshed in right now regarding NDAs. And I think what this project has really highlighted to me is that laws and the laws we choose to pass are really related to what we value. The fact that states continue to pass these NDA limitation laws, even in the wake of the Federal Speak Out Act, goes to show that each state and their population's concerns about how NDAs are used to silence and chill people who have experienced sexual assault and harassment, people who have experienced racial discrimination in the workplace. It goes to show that this is such a major, it's something that is so important, or the impact it has is something that it needs legal redressing. And so that's why I chose to flip the question. It's not a matter of why more states don't have these NDA laws. It's more like, when will more states pass more NDA laws? Because again, I think this is what the momentum is building towards.
Yeah, and I think just going off of that as well, obviously we have a representative democracy. And so lawmakers pass laws that their constituents demand and ask for. And so I think we've seen throughout the presentation, there are a lot of misconceptions that surround whistleblowing and NDAs. And so until those kind of misconceptions get debunked, I'm not sure there's going to be the demands on lawmakers to be passing those laws. I think we're starting to see that movement now and the tide turn in the last 10 years. But I mean, going into this project, kind of the one whistleblower I had in mind was Edward Snowden, who I don't think has the best connotation of anyone here. And so I think until you start to see more positive whistleblower stories being promoted and presented, I'm not sure that change will happen.
I think that NDAs in particular are before there were like more tactics just used against whistleblowers in general. And now the NDAs may be being used more as a tool. And so it's almost like, because actually whistleblower protections are a thing that has been enshrined in the US for a very long time. In fact, since the beginning of since the Revolutionary War, there have been some form of whistleblowing in our history. And whistleblowing is a very bipartisan issue, actually, in the federal, and I don't know about whistleblowing protections in general in the states, but it has been a protected issue, I would say, over the past 30-ish years, 40-ish years. And so I really think that NDAs are just a new tool to suppress workers. And therefore now the pushback is like, because this is a tool being used to suppress workers, now there are people who are trying to protect workers from this tool.
So that's all the time we have. Thank you, everybody, for coming.